Hi, my name is Mitchell Condie, and today I will be talking about James Alderson, an accountant, and his reaction to an unethical situation where he worked, using the IMA Statement of Ethical and Professional Practice. In 1993, James Alderson filed a lawsuit against four very large hospital and healthcare companies after losing his job for refusing to help his supervisor commit fraud. In 1990, while working for North Valley Hospital, Clyde Eder, one of Quorum Healthcare Management's administrators, asked Jim and Jack Sheasel, a consultant, whether they prepared two separate cost reports. They told him they did not. Quorum, the hospital's newly hired management company, submitted aggressive cost reports to the government, claiming as many expenses as possible. But to hedge against the possibility these claims would be rejected by a subsequent audit, they prepared a second, more conservative set for internal use. They estimated how much the filed report could be potentially reversed, and they held that money in reserve. After 2 years, if an audit did not reverse the claims, they would book the reserves as revenues. Jim said he did not like the idea, and when he told Mr. Eder he wouldn't be doing two cost reports, Mr. Eder left without further comment. Jim and Jack looked at each other and concluded that it sounded like fraud. A few days after the encounter, Jim was fired during a business trip to Alaska by Mr. Eder. Not being able to find a job, Jim and his family moved away. He later filed a wrongful termination lawsuit which allowed him to get documents to back up his fears that Quorum and its former parent, Hospital Corporation of America, manipulated cost reports. He later learned that he could file a qui tam case which allowed an individual to file a fraud suit on behalf of the government, and he so did. The government originally had 60 days to join his lawsuit, which was filed under seal, but they continued to ask for extensions, ending up totaling 5 years. In all that time, he was unable to tell anyone outside of his immediate family and those he hired about the lawsuit. Finally, in 1997, the government officially joined the lawsuit, and it was unsealed, but not without Mr. Alderson having to hire two outside law firms and a former Medicare auditor to push the lawsuit along. Jim Alderson did a great job by abiding by the principles outlined in the IMA Statement of Ethical and Professional Practice. He was an honest man who gave an objective, fair, and honest opinion to his supervisor when he asked him to create two cost reports. He understood his responsibility he had to the public and to himself to act with integrity. In complying with the standards set forth by IMA, Jim Alderson was a competent accountant with a background working for Arthur Andersen. He also upheld the law when he was approached to do something unethical. After filing his lawsuit, he studied relentlessly on the law regarding the situation in which he was placed and provided accurate and reliable information. He kept the information confidential, and he was unable to tell anyone besides his family and those he hired for a period of 6 years. He made sure that those he hired signed confidentiality agreements, and the information he used was obtained legally from separate lawsuits. He acted with integrity to protect the company for which he worked, his co-workers, and himself. After his dismissal, he found other work, and finally, when the lawsuit was unsealed, he notified a board member of his involvement. He sought outside counsel as well as an expert in the field to analyze his findings to ensure a credible, objective approach to the case. He sought the assistance of the U.S. Attorney General's office and worked with them to approach the case in the manner established by law. In Jim's case, it is hard to know whether he would have even been given an opportunity to resolve the issue according to the guidelines and IMA statements, because he was fired shortly after hearing about the issue. I do not believe, however, that Jim used many of these steps before being terminated. With an ethical issue such as this, I believe he should have worked with the firm first to discuss the matter with his supervisor or with company management. He may have been able to help company discontinue the practice knowing their own employments disagreed with their stance. He also did not call any helplines. However, he did consult with attorneys and was forced to dissociate with the firm. Afterward, I think he did more than many people by seeking to correct the ethical issue, even though he had no longer worked at the hospital. Overall, I think his approach to resolving the issue made sense for the situation, Although he had done more immediately after the conversation, he may have never been caught up in the lawsuit. Thank you for listening.